Prison Reforms: Abolishing Involuntary Servitude and Slavery by Ethan Steve Rodriguez. 13th Amendment Loophole: Penal Labor and Mass Incarceration. The year the Civil War ended, the US amended the Constitution to prohibit slavery and involuntary servitude, but it purposefully left in one big loophole for people convicted of crime. The 13th Amendment, ratified in 1865, says neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States and any place subject to their jurisdiction. Scholars, activists, and prisoners have linked that exception clause to the rise of prison systems that incarcerate black people at more than 5 times the rate of white people and profit off of their unpaid and underpaid labor. What we see after the passage of the 13th Amendment is a couple of different things converging, says Andrea Armstrong, a law professor at Loyola University in New Orleans. First, the 13th Amendment text allows for involuntary servitude where convicted of a crime. At the same time, black courts in South created new types of offenses, especially altitudinal offenses, not showing proper respect, those type of things. After the Civil War, new offenses like malicious mischief were vague and could be a felony and misdemeanor depending on the supposed severity of behavior. These laws sent more black people to prisons than ever before, and by the late 19th century, the country experienced its first prison boom. Legal scholar Michelle Alexander writes in her book, The New Jim Crow. After a brief period of progress during Reconstruction, African Americans found themselves once again virtually defenseless, Alexander writes. The criminal justice system was strategically employed to force African Americans back into a system of extreme repression and control, a tactic that would continue to prove successful for generations to come. States put prisoners to work through a practice called convict leasing, whereby white planters and industrialists leased prisoners to work for them. States and private businesses made money doing this, but prisoners didn't. This meant many black prisoners found themselves living and working on plantations against their will and for no pay decades after the Civil War. Was this slavery by another name? Armstrong argues that the 13th Amendment made an exception for involuntary servitude, not slavery, and that there are important historical and legal distinctions between the two. However, she says no court has formally dealt with this distinction, and many courts have used the two terms interchangeably. In 1871, the Virginia Supreme Court ruled that a convicted person was a slave of the state. Involuntary servitude: how prison labor is modern-day slavery. Joseph Lascazes, manager of the Smart Justice campaign of the ACLU of New Hampshire, looked forward to his job in the woodworking facility while incarcerated in New Hampshire. He says it helped to relieve the monotony of prison life and gave him a chance to learn a new skill. Woodworking is not the most common of trades though. The number one job in prisons is the job of a barber. People spend years cutting hairs, becoming amazing barbers, explains Lascazes. But the irony is tremendous. Once they are released from prison, they cannot become barbers because it's illegal for felons to receive a barber's license. This irony is a part of what activists call the prison industrial complex. What is the prison industrial complex? Why do people keep referring to prison laborers as modern-day slavery? What type of labor is performed by incarcerated people? Do they make money off it? And how should incarcerated people be allowed or required to spend their time? There are some notable formerly incarcerated individuals themselves who argue that the issue of prison labor is overplayed or misplaced in social justice activism. Some argue that the real problem in prison is boredom and not overwork, and argue that the solution is more diverse job training, not less labor. Others argue that the labor brings meaning to life, and anti-prison labor activists deter companies from contracting fairly with prisons, which would be a good thing. For fear of criticism from contacting with prisons at all, they seem, however, to be conscious that the status quo is unfair. This concerns, however, around two main issues: the condition of prison laborers and the impact of the prison labor industry on mass incarceration. Even if one were to argue that incarcerated people do not deserve to work in the same condition as everyday citizens, one would still be faced with the fact that allowing the proliferation of prison labor incentive the mass incarceration of largely black and brown folk to their detriment and to the benefit of big businesses. If the goal of prison laborers, as PIECP states, is to contribute to the rehabilitation of incarcerated people to facilitate their reintegration into society, then I believe a few things need to change. Incarcerated people must be afforded the same labor rights as every employee, especially the right to report unfair, discriminatory labor practices without fear of retaliation. Incarcerated people should be paid commensurate with their job difficulty and the prison economy. Incarcerated people may not be forced or otherwise coerced into dangerous work. If they choose to engage in such work, feedback and safety protocols should be robust. No company should be able to benefit from prison labor if they are willing to hire formerly incarcerated individuals. There should be well-established pathways for incarcerated employment and employment after re-entry. Past incarceration status should be added to the system of protected characteristics for employment. In summary, in a system modeled off of slavery and under threat of punishment or lack of funds for necessities, most incarcerated individuals work full day, making less than $1 per hour, with no benefits and with no guarantee of post-release employment. While one may argue that incarcerated people should be satisfied to have any work or economy at all, the conditions of their employments are not livable. Joseph Lascazes does not like telling people he is formally incarcerated, but he says he does so both for transparency and to initiate a cultural shift. While campaigns like Ban the Box, a push to remove the criminal record checkbox for jobs applications are popular, Lascazes thinks that what is ultimately needed is for society to view people with criminal records first and foremost as people, which I can agree. Thank you.